In 2000, India passed the Information Technology Act to give legal recognition to e-commerce and digital communication. Social media barely existed. Today, digital platforms influence elections, markets, public opinion, and even national security. From fake news to deep fakes and algorithm manipulation, the internet is no longer a neutral space. The Digital India Act Draft 2025 aims to replace the 2000 framework to address platform power, user safety, and technological risks. The key shift lies in how the law treats intermediaries, moving from safe harbor protection to structured accountability. Under the IT Act 2000, intermediaries such as social media platforms, search engines, and e-commerce sites were protected by Section 79, commonly known as the Safe Harbor provision. This meant that platforms were not legally liable for third-party consent hosts on their platforms, provided they followed due diligence and removed unlawful content upon receiving actual knowledge through court or government notice. The logic behind Safe Harbor was simple. Platforms were treated as neutral conduits like post offices. They carried content but did not create it. If they were made liable for every user post, digital innovation would have been crushed at birth. This principle aligned with global norms like the US Communications Decency Act Section 230. However, over time, platforms stopped being passive carriers. Algorithms curate content, amplify certain posts, and influence user behavior. Platforms monetize attention and shape public discourse. The passive intermediary assumption became weak. Problems like misinformation, hate speech, child sexual abuse material, deepfakes, and coordinated disinformation campaigns exposed regulatory gaps. The Digital India Act Draft 2025 proposes a shift towards an accountability based model. Instead of blanket immunity, liability will depend on the platform's size, role, and risk profile. This introduces graded obligations. First, the new framework distinguishes between simple intermediaries and significant digital platforms. Larger platforms with systemic impact will face higher compliance requirements, including algorithmic transparency, risk assessment, and content moderation accountability. Second, Safe Harbor is conditional on proactive compliance. Platforms may be required to implement systems to prevent harm, not just remove content after notice. This moves from a reactive model to a preventive model. Third, there is an emphasis on due diligence, grievance redressal mechanisms, traceability in specific cases, and cooperation with law enforcement. Failure to comply can lead to monetary penalties, loss of safe harbor, or even criminal liability in extreme cases. Fourth, emerging harms like deep fakes and AI-generated misinformation are explicitly recognized. The draft signals regulation of algorithmic amplification and dark patterns. The contrast can be understood in three dimensions. First is the legal philosophy. The 2000 Act assumed intermediaries are neutral. The 2025 framework recognizes platform power and responsibility. Second is the nature of liability. Earlier, immunity was default unless due diligence was violated. Now, immunity is earned through continuous compliance and risk mitigation. Third is the regulatory approach. The old regime was light touch and innovation focused. The new regime balances innovation with user safety, national security, and demographic integrity. However, the accountability model must be carefully designed. Excessive compliance burdens may hurt startups. Over-regulation may lead to censorship and chilling effect on free speech under Article 19(1)(a). Therefore, proportional regulation and clear procedural safeguards are essential. In conclusion, the Digital India Act represents a paradigm shift from platform as messenger to platform as responsible digital gatekeeper. The future of India's digital governance lies in balancing innovation, accountability, and constitutional freedoms in an age where technology is no longer neutral but deeply political and social.